Good morning, everyone, and welcome to the class. In the previous class, we were discussing about the judicial activism. Our discussion was not complete. Uh, Under this judicial activism, we have discussed about the public interest litigation, how this public interest litigation is started in the judicial system of India. And in this regard, the two main incidents were there, and we have discussed about it. Now, today we will continue our discussion in on the this topic only, and what we find that how public interest litigation is beneficial, how it proved beneficial for the people of the country. What are the advantages? We can say it. What are the advantages of public interest litigation? The first most important thing what experienced by the people that because of this PIL, what happened that the court has expanded the idea of rights. For example, our constitution gave us right to life, but this right to life is a very there is no many things which are not included in this right to life. But after through various PIL and not only we can say that PIL, there were many cases arose which through which the idea of this right to life was expanded, and many new things included in this right to life, like right to safe drinking water, then right to livelihood, right to shelter. All these things were included by only by the judiciary, only by the activity of the judiciary. We can say only by judicial activism. The scope of right to life was expanded, and so many new rights have been included in this right to life. So this is a very positive impact of judicial activism. This is a very positive impact of public interest litigation, because these the judgment of the Supreme Court and the PIL has widened the scope of rights, and people, especially those who are the weaker section of the society, those who are the poorer section of the society, it is very much beneficial for them, because in the views of the court, uh, that individuals, as part of the society, must have the right to seek justice wherever such rights were violated. So, nothing should come in the way of achieving justice. Any individual who is a part of a society, he or she must have the right to seek justice if there is any kind of a violation of the justice. So we can say because of judicial activism, the idea of right has been expanded, the scope of rights has been widened. Now the second benefit which we can say we got from PIL and judicial activism, it was because of in judicial activism, we see that this activism has proved beneficial mainly for the poor section of the society, because in our country, the legal system, the procedure of judicial procedure is so much complex, and it takes so much time and money also, that a poor person cannot afford to go to the court, because a poor person is not having that much of knowledge of the legal matters, he is not aware of his rights. First of all, there is problem of education. People are not educated. People are not aware. They are not knowing their rights. They are not knowing that if there is violation of the rights, then what should they do. First of all, this problem is there with the poor section of the society. Then the second problem, which is associated with this particular section of the society, is that many times they are knowing the their rights, they are knowing the laws which the government has enacted for their advantage. They are fully aware of everything, but still they are not they are still they are getting exploited, and they are not raising their voice against this exploitation. They are not going for they are not going to the court for remedy. So they are knowing that they are getting exploited. They are knowing that there is a violation of the fundamental rights of the people. They are knowing that their fundamental right is being violated. They are knowing that the rules of the government, the laws of the government are not followed by some people, those who are exploiting them. So everything is known to the people who are getting exploited, but still they are not going to the court. They are not taking the help of the legal system of the country. The reason behind it, the legal system of our country is very complex, and people need money. People need time in order to pursue the legal process, and they don't have. They neither have time. They neither have money to to follow the uh, legal system of our country. So they prefer to get exploited instead of going to the court. So this is the condition of the poor section of our society. So in this situation, what we find that the judiciary, there must be some provision that it is not necessary for the victim to go in the court on behalf of the victim. Any public spirited citizen or any organization or any lawyer, anyone other than the victim, can also file petition. So this is what PIL. So the situation which is prevailing in our country is very much there can be justice in a country like India. There can be justice. There cannot be justice without PIL. PIL is very much needed for for implementing a just society. You must be remembering the uh, when our chapter on fundamental right started, two incidents were discussed. The first was about some construction work was going on, and the labor contractor was totally um, not following the rules of the government regarding the um, labor, and they were exploited. Their working condition was so bad, but they all were doing the work without any agitation and without any dissatisfaction. And then what happened that a team of social workers uh, took this issue to the court. So what is this? This is PIL. This is the advantage of PIL. जिन लोगों के पास न तो एजुकेशन है, न मनी है, न टाइम है, उनको कैसे जस्टिस दिया जाए? They can get justice only through PIL. So this is the most important uh, benefit of judicial activism. Now, as we all know, I told you, Justice Bhagwati is called the pioneer of PIL, though it was started by Justice Iyer, but the case of Bhagwati became more popular. And in the case Bandhua Mukti Morcha versus Union of India 1984, it was the judgment of this is the excerpt of judgment of Justice Bhagwati. It must be remembered that the problems of the poor are qualitatively different from those which have hitherto occupied the attention of the court. So, what is the view of Justice Bhagwati? Justice Bhagwati is of the view that there is a difference between we can say that there are two classes, two section in the society. One section is that section which is coming to the court with their petition, and they are filing the case, and they are pursuing justice. And uh, there is another section which is not able to do all these things. So there is difference between these two sections, and we must understand that difference. It must be remembered that the problems of the poor are qualitatively different from those which have hitherto occupied the attention of the court. The court is only giving attention to those people who are coming to them. But what about those people who don't have courage, who don't have money, who don't have time, who don't have knowledge to go to the court? What about them? They need a different kind of judicial approach. If we want to uh, mm, give justice to that section of our society under this system which was prevailing at that time, under the system which was prevailing at that time, we cannot give justice to that section. If we want to give justice to that section, to the poor section of the society, what we need a different kind of judicial approach. And what is this different kind of judicial approach? This is PIL. Okay, if we blindly follow the adversarial procedure in their case, they would never be able to enforce their fundamental rights. So, it is the opinion of Justice Bhagwati that what happens in a simple case, normally in a case, what happens that the parties which are in dispute, the parties are responsible for finding and presenting evidence. This is called adversarial procedure. So this is a new term, and you must know the meaning of this term. Adversarial procedure is uh, that procedure in which the parties who are parties to a dispute, the parties in a dispute are responsible for finding and presenting evidences. So, if we will follow that procedure, then what will happen? That the if the party is a poor person, then he will not be able to present the evidence and all these things. He needs support, and he must be given support if we want that they must enjoy their fundamental right which is given by the constitution to all in an equal manner. So this is a very important judgment of Justice Bhagwati. Now we will see that the impact of judicial activism. What is the impact of judicial activism on the political system? Uh, we can say that because of this judicial activism, the democracy, uh, our judicial system has become more democratic, because Now, the justice is delivered not only to individual, but uh, groups can also access the court. So it democratized the judicial system. uh, because of judicial activism. Now the uh, an individual who is the victim need not to be the person who can file the case. Other person or other group can also file a case on behalf of that uh, aggrieved person. So this is the process, and through this process what happened, that the judiciary has become more democratic. Now the poor people are also able to get justice only because of PIL. So now we will see that some many important judgments have been taken by the judiciary, and these important judgments are related to many electoral reforms also. Uh, we can see that the court has asked candidates who are contesting elections to file affidavits, in which affidavit they have to declare their asset, okay, whatever asset they are having, and their income also. Other than asset and income, they have also uh, give information regarding their educational qualification. And not only this, nowadays, because according to the judgment of the Supreme Court only, uh, all the candidates also need to mention about the cases which are there against the candidate. Number of cases, how many cases are going on in various courts of the country against the candidate. He has to give the numbers of the cases, all criminal cases. So this is what, this is a very we can say it's a, uh very good effort on the part of the judiciary in order to make our elections free and fair, in order to make our democracy more qualitative. Because when the candidates are filing the affidavit regarding their assets and income, and their educational qualifications and number of cases, then what will happen, that all the people will become, the people of the constituency especially, will become aware of his income, his assets, his or her educational qualification, and criminal cases. About criminal cases, they will also become aware. And in this, under all the, मतलब सब कुछ जानने के बाद people of the constituency will give their vote. So this is what, this is for the knowledge of the people, knowledge of the voter. The voters must know that if they are going to give vote to a particular candidate, then what is the educational qualification of that candidate, how many cases are there against him or her in the courts of India. So in this way, it is a very very effective judgment in order to make the electoral system more fair. Okay, and in this regard, you must you may be knowing or not knowing, uh, when Smriti Irani filed her affidavit, and in her affidavit there was the educational qualification which was filed by her, which was mentioned by her, that was challenged by another the opposition party, because ऐसा कहा गया कि उन्होंने कुछ गलत अपनी क्वालिफिकेशन बताई, अपनी डिग्री को बढ़ा के बताया है. तो these are the cases. Then क्रिमिनल केस के कारण ऐसा भी हुआ अभी रिसेंटली हमारे बलिया के एमपी जो कि स- मायावती की जो पार्टी है उससे वो इलेक्ट हुए थे एंड ही वॉन द election. But BSP, Bahujan Samaj Party, he was the candidate of Bahujan Samaj Party, and he was able to win the election also. But because of the criminal cases were there against him, and because of those criminal cases, he was not able to uh, hold his uh, position. So these are the reforms which were made by judiciary. But actually, uh, these reforms should have been should have been done by the executive or the legislature. But now what we are seeing that the judiciary is doing that work which is supposed to be done by the executive or the legislature. So we can say it is the interference. It is a kind of interference in the functioning of the different organs of the government. In our country, we have uh, adopted the separation of power, under which there is three organs of the government, and all the organs have their own jurisdiction, and no one should interfere in the jurisdiction of the other. But uh, because of this judicial activism, what we see that the judiciary is uh, involved in resolving questions which are actually belonging to the executive. Suppose there is a judgment regarding the reduction of air pollution, sound pollution. Then there are judgment regarding investigation cases of corruption. Then bringing electoral reforms, which we have discussed just now. So all these are not the duty of judiciary. Judiciary is not supposed to do all these work. These works belong to the executive. So this is interference. Okay, this is imbalancing the balance which should be maintained between the three organs of the government. This judicial activism is creating imbalance. It is interfering in the jurisdiction of executive as well as legislature. So this type of interference is not good for we can say it's not good for democracy also, because democratic government is based on each organ of government respecting the powers and jurisdiction of the others. So this should not be done. Judicial activism may be creating a strain on this democratic principle. So it is, on the one hand, we saw that it is because of judicial activism, the poor are getting justice. It has made our judicial system more democratic. But on the other hand, we are seeing that uh, mm, judicial activism is actually interference in the jurisdiction of other organs. So it is hampering, it is obstructing the democratic principle of separation of power. So this should not be done. And then one more problem is associated with this judicial activism, because we know that our judiciary is overburdened, because the court cases are so lengthy and it takes so much time, so many years are taken by each cases, that our judiciary is always function in a delay. It is always delaying. So by PIL and by judicial activism, its burden has been increased. It has been overburdened. Now there is one situation is given, which I am going to read. A group of citizens from a city have approached the court through a PIL, asking for an order to the city municipal authorities to remove slums and beautify the city in order to attract investors to the city. They argue that this is in the public interest. The residents of the slum localities have responded by saying that this will encroach on their right to life. They argued that the right to life is more central to public interest than the right to a clean city. So, this kind of PIL is what? It is actually against the poor, because it is asking the city and the court for an order to the city municipal authorities to remove slums. And we know that slums are the residing places of the poor. Our poor people lives in slum. So in order to beautify the city, in order to attract investors to the city, so that the city can grow economically, the PIL is asking for asking the court to pass an order so that the city municipal authorities can remove the slum dwellers and slums. So this is totally against the public interest. It is not in the public interest, because uh, mm, they cannot deny the people their right to shelter, because right to shelter is also a part of right to life. So this type of situation is given to you when you are imagined as a judge, and then you have to write a judgment. Uh, how does this PIL involve public interest or not? So now we will consider this judiciary and rights. How judiciary is made the protector of the fundamental rights of the people. Regarding this, we have discussed in the chapter fundamental rights also, and in this chapter also we have discussed the writ jurisdiction of the Supreme Court and High Court also. So that is very much known to you. Under Article 32, if there is violation of any fundamental rights of the people, people can go to the Supreme Court and High Court, and in order to protect the fundamental rights of the people, the court will issue different writs, like habeas corpus, mandamus, certiorari, quo warranto. Okay, so these are the uh, writ jurisdiction of Supreme Court as well as High Court. And in this regard, these are the two most important article. Article 32. Under Article 32, the Supreme Court has the uh, right to issue writs, and under Article 226, the High Court has the right to issue writs. Okay. Now there is one more system, one more practice has been evolved, and this is called uh, judicial review. Under this, what happens that the Supreme Court has the power to declare any law as unconstitutional, because there is some provisions in the law, something in the law which is against the provisions of the constitution, and on this basis the Supreme Court has the authority to declare it non void, and declare it null and void. Null and void means नॉन ऑपरेशनल हो गया, उसको खत्म कर दिया गया. दैट लॉ विल नॉट एग्जिस्ट एनी लॉन्गर. दिस इज आर्टिकल 13. Okay. So these two provisions of the Constitution establish a Supreme Court as protector of fundamental right. First, red jurisdiction, and the second is the uh, power of judicial review. Okay, and not only the Supreme Court plays the role of the protector of fundamental rights, but it also plays the role of interpreter of Constitution. Interpreter of Constitution means if there is any kind of confusion regarding any provision of the Constitution, if it is not clear, there is ambiguity uh, regarding what the constitutional provision is saying. It's not clear. There is ambiguity in that matter. Then what happens? The matter goes to the Supreme Court, and the Supreme Court has been given the function. The Supreme Court has been given the responsibility to interpret the Constitution, and this interpretation of Constitution, which is done by Supreme Court, that is final. And how do they interpret? They interpret uh, by in this regard. I am telling you, uh, the Constituent Assembly. There was a huge debate in the Constituent Assembly. Oral debates were there. Then so many written documents were there. So all these debates and discussions, whatever done in this Constituent Assembly, oral debate and discussions, written documents, other than and written documents plus oral debate and discussions, all were compiled in the form of books. And there are 12 volumes of these books, which are called Constituent Assembly Debates. And these books are kept in the library of the parliament. And whenever some uh, matter arose regarding, whenever some matter arises regarding the provision of constitution, uh, whenever there is ambiguity in the provision of the constitution, then our judges of the Supreme Court refer that book, Constituent Assembly debate, and then they decide, they interpret the provisions of the Constitution. So these are the two important functions of the Constitution, which will be discussed in the next class.